What's the next panel right away?
A 10-minute break. Yeah.
Oh, okay.
I mean, if you are inclined to talk to someone, you're welcome to step out of it.
Yeah.
There were a couple of people that came
The
up
second
to.
panel starts at 11 or?
We go till 11:25, and
Oh,
they
okay,
start
so
10 minutes
noon.
after that.
Okay. Good. Yeah. No, I still have time for that because my flight is early this afternoon. I have
Okay.
to, well, is traffic to Dallas bad?
Dallas, you're going to Dallas.
Lisa went to sloan school,
No,
and then
no.
she had to get teaching certification.
Especially early
So she had to go to Mercer County Community College and Ryder. And she said the most important class was on classroom management.
That's not surprising.
Okay, I think we're going to get started. It's great to be back at Antonin Scalia Law School. My name is Bruce Kobayashi, and I've been a faculty member here since 1992. I'm currently on leave and serving as the director of the Bureau of Economics. And in that capacity, it's my honor and pleasure to be able to introduce our opening speaker for our two morning panels on antitrust and labor markets, Professor Alan Krueger. Professor Krueger holds a joint appointment at the Department of Economics and the Woodrow Wilson School as the Bentheim Professor of Economics and Public Affairs at Princeton University. It's a particularly appropriate choice to open our labor market sessions, having published widely on the economics of education, unemployment, labor demand, income distribution, social insurance, and labor market regulation. In addition to a long list of academic articles, he has published multiple books, including his co-authored book with David Card on Myth and Measurement, The New Economics of the Minimum Wage, and a book that I have put on my reading list, Rockonomics, How Music Explains Everything About the Economy. Especially since I saw in the blurb that he interviewed the manager of the Red Hot Chili Peppers. Professor Krueger has served in the government. He was the chairman of the Council of Economic Advisor and a member of President Barack Obama's cabinet from 2011 to 2013. Just prior to that, he served as Assistant Secretary for Economic Policy and as a chief economist for the U.S. Department of Treasury from 2009, 2010. And way back in the day when we were all younger, he's still younger than I am, he was chief economist at the U.S. Department of Labor. So Alan certainly knows a lot about labor and public policy. He's held high positions in the American Economic Association, served on the executive committee, won numerous awards, too lengthy to mention. Here's his resume. It's double-sided. But let's give a warm welcome to our opening speaker, Alan Krueger.
Would you like me over there or stay here? Either way.
The idea is you would go up there, but whatever suits you.
Thanks very much for that generous introduction, and especially for plugging my book, which will be out in May, but you may especially be interested in the book by Flea of the Red Hot Chili Peppers, which covers the first 18 years of his life, which will be out around the same time as mine, which I'm concerned may be competition. I want to thank the FTC for inviting me and for holding this set of hearings. It's really an impressive set of topics that are being discussed by a very impressive set of researchers and others. What I thought I would do is give an overview of how I see competition and lack of competition in the labor market. I think this is a particularly appropriate time to have this discussion. Research on labor economics has been growing very quickly on non-competitive practices and on the non-competitive workings of labor markets. I think this is a topic which is very important. I think it's one in which the evidence is still evolving. We face similar kinds of challenges in the labor market as industrial organization economists face in looking at product markets in terms of defining the scope of a market. In fact, in many ways, I think it's more difficult in the labor market because every individual is unique. That said, I think there's a growing body of evidence which suggests that the go-to model of the labor market, which has historically been one of perfect competition, is probably not the best model to use in many situations. In a perfectly competitive model of the labor market, bargaining power is completely irrelevant because wages are determined by the external forces of supply and demand. Firms just passively accept whatever the market wage is. In many applications, I think it is more appropriate to model the labor market as imperfectly competitive. And Bob Topel arrived just in time. Subject to monopsony-like effects, collusive behavior by firms, surge frictions, and surpluses that are bargained over. As a result of these labor market features, I think it's often more appropriate to view firms as wage setters or wage bargainers rather than wage takers. This perspective can explain many well-documented phenomena in the labor market, such as the high variability in pay for workers with seemingly identical skills who work in different industries or in different firms, the lack of evidence that minimum wage increases reduce employment, and the reluctance of firms to raise wages despite facing vacancies. Now, I've noticed that many economists are reluctant to accept the idea that markets are manipulable, that firms or traders have some power over prices and wages. When I worked at the US Treasury Department in 2009 and 2010, and I had the opportunity to work with some of the best finance economists in the world who were on leave to help during the financial crisis, my colleagues thought it was inconceivable that foreign exchange markets or LIBOR could be manipulated. After all, these are the largest and most liquid markets in the world. Only later did we learn that several traders have been convicted of colluding on exchange rates and that LIBOR was totally rigged. Interestingly, the people who I worked with who came from the markets, who actually had experience trading, thought this was quite the norm. Now, one economist who thought that labor markets are imperfect and subject to manipulation was Adam Smith. In The Wealth of Nations, Smith wrote, quote, "Employers are always and everywhere in a sort of tacit but constant and uniform combination not to raise the wages of labor above the actual rate. To violate this combination is everywhere a most unpopular action and the sort of reproach to a master among his neighbors and equals." Smith ridiculed naysayers who doubted that employers colluded as, quote, "ignorant of the world as of the subject." And then in full conspiracy mode, he added, quote, "We seldom indeed hear of this combination because it is the usual, and one may say the natural state of things, which nobody ever hears of." Now, you don't have to look too far to find evidence of the conspiracy that Adam Smith warned about. In an ongoing FTC case involving physical therapists in Dallas and Fort Worth, the language rings very similar to what Adam Smith wrote about, only it's been more modernized with texting. The owner of one physical therapy company wrote another, "Yes, I agree. I'll do it with you." You was spelled you, not Y-O-U. And do it was referring to jointly agreeing to lower wages. Now, I'll return to some other cases involving collusion in the job market. Broadly speaking, there are two varieties of economic models that give employers some discretion over wage setting. The first, pioneered by Joan Robinson, is a static monopsony model where there's a single employer who faces an upward-sloping labor supply curve. This could be easily extended to a small number of employers, oligopsony, and it could be extended to Smith-like situations where employers jointly collude to suppress pay below the competitive rate. The second class of models, which were pioneered by Ken Burdett, Dale Mortensen, Chris Pissarides, Peter Diamond, and extended recently by Alan Manning, rests on search frictions. And there are a variety of different types of search models. But basically, it takes time and effort for workers to search for job openings and for firms to search for workers. As a consequence, if a firm pays a little less than the going wage, it would not lose all of its workers or find it impossible to hire new ones. In fact, there is no single going wage in these models, but a range of plausible offers that firms could make or bargains that firms and workers can strike. As a practical matter, both classes of models are equivalent to assuming that the labor supply curve to a firm is upward sloping instead of infinitely elastic. Firms would operate with costly vacancies in these models, yet resist raising wages because pay would need to be increased for all workers, not just the incremental hired worker. And if employers collude to hold wages to a fixed below market rate, or monopsony power increases over time, then wages could remain stubbornly resistant to upward pressure, even at a time when the economy is booming. So with this framework as background, I'd like to make 4 observations about the labor market that I think are particularly relevant at a time when we're seeing relatively weak wage growth despite 50-year low unemployment. First, average wage growth is weaker than one would predict from historical relationships between wage growth and the unemployment rate. Janet Yellen alluded to this earlier this week and said that a leading explanation for the shift in the Phillips curve is that worker bargaining power is weaker than it used to be. Although nominal wage growth has been creeping up in this recovery, over the last 12 months, nominal wage growth has barely kept pace with inflation. There are many explanations for why wage growth may be weaker than we would predict. Low productivity growth, I think, is an important factor, but low productivity growth can't account for the last year because productivity growth has picked up, yet wage growth, real wage growth, has actually weakened. Based on the specification of the wage Phillips curve that I estimated 20 years ago in a Brookings paper, I would expect wages to be between 1 and 1.5% stronger today than they have been. Second observation, there's growing evidence supporting an important role of monopsony power in the job market, stemming from both employer concentration and dynamic labor market considerations. I won't go into too much detail on this work because one of the main contributors, Iona Marinescu, is here. But basically, this work finds that measures of employer concentration, either measured by concentration within an industry in a county or of employment within an industry in a county, and work by Melick and co-authors, or measured by job openings posted online for occupations within a small commuting zone, show a relationship with wages, which suggests that in more concentrated areas, wages are lower, other things being held equal. There's also some evidence that concentration has increased, although again, I think it's important that we define the boundaries of the labor market carefully in that work. Other studies have looked at monopsony power within specific industries. And here I think the most work has been done in the nursing industry. Dan Sullivan in 1989, Doug Steger in 2010, and co-authors found substantial evidence that hospitals are able to use monopsony power in setting wages for nurses. Then lastly, there's evidence on dynamic monopsony power. For example, Doug Weber has used the longitudinal employer household dynamics data set to estimate labor supply elasticities to firms. Specifically, he looked at how turnover relates to the generosity of compensation across firms. He found that the average labor supply elasticity to a firm was 1.1. He also found considerable variability across firms. And the firms that had a more inelastic labor supply tended to pay lower wages, as one would expect if they take advantage of their monopsony position. Third, monopsony power and search frictions have probably always existed in the labor market, but the forces that traditionally counterbalanced monopsony and boosted worker bargaining power have eroded in recent decades. The most obvious is labor unions. Union membership fell from 25% of the workforce in the US in 1980 to 10.7% last year. Collective bargaining used to be an effective counterweight to monopsony power. We used to write papers on the union threat effect, but in most industries, there's hardly any union threat effect. So the spillover effects where companies might raise wages to try to prevent having a union drive is weaker than it used to be. Another counterbalance to monopsony power that is weaker today is the minimum wage. The US federal minimum wage is currently $7.25 an hour. It has not been raised since July of 2009. The real value of the minimum wage is down by about 20% since 1979. By contrast, in that period, both the UK and Germany enacted their first national minimum wages, and they currently stand at $10 an hour at current exchange rates. The decline in unionization and the erosion of the real value of the minimum wage have been found to significantly contribute to higher income inequality and polarization in the US workforce. These shifts have also probably contributed to the downward trend in labor share in the US since the 1990s, after decades of stability. Now, one might argue that these changes to the labor market have made the labor market more competitive. But the fact that the employment to population rate has trended down, especially for the workers who were covered by collective bargaining and affected by the minimum wage, and that regional shocks are now more persistent for wages, employment, and labor force participation, suggests that we have a less competitive labor market with weaker bargaining power and more monopsony power. Fourth, there has been a proliferation of practices that enhance monopsony power and weaken worker bargaining power. I'll highlight 5 of these practices. First, there's been increased reliance on temporary help agencies, staffing firms, and outsourcing. One implication of this practice is that firms can wage discriminate. This can facilitate monopsony. If a hospital has persistently high vacancies for a nursing position, it can reach out to a staffing firm, hire a staff nurse from the firm, and pay a higher salary to that particular nurse than other nurses who are employed by the hospital. Second, a quarter of American workers are bound by a non-compete restriction on their current job or from a previous job. These restrictions, which may be justified in a limited number of cases to protect returns to specific training or trade secrets, have truly run amok. Even Jimmy John's used the practice for submarine sandwich makers until they were forced to drop it. Just over 1 in 5 workers who earn less than the median wage are bound by a non-compete restriction on their current or previous job, according to work that Eric Posner and I have done, and I'm sure we'll hear more about non-competes later from Evan Starr. Non-compete agreements reduce workers' options and reduce mobility and bargaining power. Third, a growing fraction of the workforce is covered by occupational licensing restrictions, typically imposed by state and local authorities. Morris Kleiner and I, for example, find that over a quarter of workers are required to obtain a license to perform their job. These restrictions may be justified in positions that require extraordinary skill or put the public at risk, but they also restrict job opportunities and mobility. Occupational licensing is also run amok. It's particularly difficult for workers who want to change jurisdictions, change states. It is especially a burden on military spouses. Military families move around often. The most common jobs for military spouses are nurses and teachers who often have to get licensed in the new state when they move, pay licensing fee, and by the time they are permitted to work in those states, they often move again. Fourth practice, my colleague Orly Ashenfelter and I have found that 58% of franchise companies have a no poaching clause in their franchise contract that prevents one franchisee from hiring workers from another franchisee or from the franchise company itself if the company operates stores. This is up from 36% of franchise companies in 1996. The practice is particularly common in fast food chains. We found that 80% of the largest quick service restaurant franchise chains had a no poaching requirement. Since the human capital that is being prohibited from moving around different outlets within the franchise would stay in the franchise company, it is awfully hard to see a business justification for this practice other than trying to suppress mobility and suppress workers' wages. Washington State took action. The Attorney General in Washington State launched an investigation and managed to persuade 30 of the largest franchise chains to drop their no poaching agreement in the U.S., in Washington State and the U.S. Almost all of the major fast food companies with the no poaching agreement have dropped that from their contract, thanks to the work of Bob Ferguson, the Attorney General in Washington State, over the last couple of months. Just yesterday, he announced that he's bringing a lawsuit against Jersey Mike's, franchise based in my state, New Jersey, which operates in Washington State and other states for continuing to use this practice. I should add that in addition to restricting mobility and increasing monopsony power, these types of restrictions on mobility, like non-compete clauses and no poaching agreements, and the no poaching agreement, which is completely blind to the worker, workers are not aware, they're not party to these agreements, they reduce workers' opportunities for finding better job matches, improving their working conditions in other ways. And work by Bob Topel and Michael Ward back in 1992 found that about a third of the wage gains in the first 10 years of young workers' careers were associated with job changes. So apart from the effect of suppressing wages at the firm where these workers work, they also reduce opportunities for the workers to move up the wage hierarchy. Now, no poaching agreements would clearly be illegal if they occurred across unrelated firms. It's an unsettled area of the law, as I understand it, if franchisees agree to these types of no poaching agreements. But as I mentioned earlier, there are violations of the law outside, outside of the franchise sector, as Adam Smith had anticipated. I could go through many examples, but I think I'm running short on time, so I'll just give you a few more. In a famous case, Apple, Google, Adobe, Intel, Intuit, Pixar, Lucasfilms were found to have colluded on not hiring each other's workers, colluding on pay setting, and paid a $500 million settlement in 2015. There have been several cases in the hospital industry addressing pay of nurses. 8 major hospitals in Detroit recently reached a $90 million settlement in the suit alleging that the hospitals colluded to reduce nurses' pay. Similar cases are in various stages in Albany, Memphis, San Antonio, and Arizona. A couple of months ago, I spoke with Jeff Suri, who is a registered nurse and was the lead plaintiff in the Detroit nurses case. I wanted to understand from his perspective how he came to recognize that this was taking place and what impact it had on his career and his work. He said that he worked at the emergency room at St. John Providence Hospital in Warren, Michigan. He was hired in 1991. He later moved to the critical care unit, and he tended patients who were recovering from open heart surgery and other serious conditions. After working there for 12 or 13 years, Mr. Suri said he got an inkling that the human resource department at his hospital was coordinating with other hospitals and setting nursing pay because he had an opportunity to see some emails where they were discussing trying to reduce mobility and coordinate on pay. He said the hospitals, the nurses at his hospital were non-unionized, and the hospitals in the area wanted to prevent nurses from jumping from one hospital to another for better pay and better working conditions. The executives would often discuss these issues and exchange pay rates at conferences. One indication that the hospitals exploited their monopsony power that he told me about was that when they had vacancies, which was often, the hospitals would reach out to a staffing firm. The staffing nurses were paid $40 an hour, plus the firm got administrative fees, while employee nurses were paid $30 an hour. A class action suit was filed on behalf of Mr. Suri and thousands of other nurses in 2006. He gave a deposition in 2007. He said the hospital, quote, made life hell for me after that. Increased his patient load to a level he considered unsafe for the patients. He quit in 2008. Other hospitals were reluctant to hire him. He now works in home health care. The antitrust suit was settled in 2010. Mr. Suri did not receive any compensation until 2012, 6 years after the suit was filed. So I think this gives an indication of the challenges that workers face in this situation and the retaliation that they sometimes can face. It's worth noting that collusion is easier when there are fewer firms in a market. The increase in employer concentration in the US has probably facilitated collusion. And collusion doesn't have to be explicit. Employers could collude at a focal point. The minimum wage could be a focal point, for example. Round numbers could be a focal point. And there's evidence that this type of tacit collusion occurs as well. Now, a really tight labor market might make it possible for this collusion to break down. I suspect that's part of the reason for the historical Phillips curve to exist in the first place. So we may see some improvement if the economy continues to improve and the unemployment rate continues to stay low. I want to conclude by saying I presented a similar set of remarks at Jackson Hole this summer at the Kansas City Fed annual conference on monetary policy. The reaction I got was quite encouraging. I think many of the monetary policy officials thought these issues are important, but probably beyond the reach of monetary policy. I think there was a consensus coming out of that meeting that these are very important issues for the Department of Justice and for the FTC to focus on. I want to commend the FTC and the DOJ for issuing joint guidance in October of 2016 for human resource professionals, clearly stating that wage fixing and agreements not to poach other firms' workers are illegal. And I think this is an area that needs a greater attention and more vigilant enforcement, because from the evidence that is available, it seems that Adam Smith was right, and there are many instances of employers combining tacitly, sometimes explicitly, as in those emails that I read before, to try to suppress pay. Thank you.
Okay, thank you, Alan, and thank you to everyone for coming or watching on the web. My name is Jeremy Sanford. I'm an economist at the FTC, and I will be one of the moderators of this panel. The other will be Devesh Raval, who's also an economist at the FTC and is seated to my left. We have a very strong panel to discuss the issue of labor market monopsony. You've already heard from Alan Kruger. The other panelists are Matthias Carrig of Duke University, Ioana Marinescu of the University of Pennsylvania School of Social Policy and Practice, Nancy Rose of MIT, and Nancy recently served as the Deputy Assistant Attorney General at the Department of Justice, and Bob Topel of Booth Business School at Chicago. So Alan's already had a chance to give remarks. The other four panelists are now going to each have up to 12 minutes to give opening remarks, and the order will be first Matthias, then Ioana, then Nancy, and then Bob. And then following that, we'll have a Q&A session in which Devesh and I ask questions of the panel. So with that, I will hand it off to Matthias.
Okay. Thank you very much for the invitation to discuss here with other academics and policymakers, economists of the FTC, concentration and market imperfection and labor markets. I'm a macroeconomist. I work on productivity and firm dynamics and how high productivity, low productivity firms evolve over time, how they hire and what pages they pay. So in principle, what I'm going to want to bring to this discussion is a little bit the firm side. How do firms decide? How do they act in labor markets? How do they respond to market condition in terms of their employment, in terms of their wages, and so on. So the first important thing that I want to say is when we talk about wages, wages are compensation for something that the worker produces for the firm, which is somehow value added per worker or gross profits per worker. So this is what I'm going to add to this. And I basically want to make 4 points here. The first point is I want to talk about how concentration evolved in markets. And when I talk about markets, I want to talk about, first of all, output markets, goods markets, and secondly, input markets, labor markets. It turns out they're actually slightly different. And that's important because when you think about how firms should typically respond to standard economic reasoning, they should be related, but they are not since the 1980s. The second point I want to make is that overall, the labor compensation and labor productivity per worker, they have diverged since the 80s. So in principle, you can think of this is the fact that the aggregate labor share in the economy, the share of GDP that is paid out as wages and compensation for workers has gone down. And the interesting aspect is when you look at individual firm level data, for the average firm, this is not the case. It is really a very small subset of very few what we call hyper-profitable or superstar firms that have tremendous productivity growth and don't share with the workers. The third point I want to say is this productivity growth primarily stems from the output side of firms. So these firms, they make incredible profits by having high relative prices compared to their peers in the same product and market and so on. It's not so much that they pay particularly lower wages. It still could be going on that the overall wage level is suppressed because of various factors that Alan Kruger mentioned, collusion, unionization, and so on. But when we single out these individual firms that have this tremendous productivity growth and no really wage payment, it's not because they undercut the wages, it's because they have relatively high prices. And the last point that I want to make is that there's a remarkable turnover at this high price end of the market, that the firms are kind of in a mutual competition overtaking each other, and that has become increasingly volatile. And that might be one reason also why they don't pay higher wages, because from their output side, they face a lot of demand risk. So first point, the concentration dynamics. So when we look at the concentration in goods markets, this is from a slide that from some work with from David Orter and others. The concentration goods market has been unambiguously going up. If you look at the share of sales accounted for by the top 4 or by the top 20 firms, what you see is that that has been increasing secularly. And that's true for many other concentration measures, such as the Herfindahl index and others. So this is based on census data. And the census data, in principle, captures all the businesses there are. So they capture, in principle, all the sales. They also, of course, record employment. And that's what I want to show to you now, is when we look at the same idea of concentration measures in the labor market, the evidence is much more ambiguous. So there's some recent work by Claudia Mercaluzzo, Brett Hirschbein, and Chen Ye, and also David Berger, Kyle Herkenhoff, and Simon Manger, that they say actually if you look at the local concentration of employment in local labor markets, this has been going down. Now there's some other work and evidence on the concentration of among new vacancy posting or job openings. So that's slightly different. What I'm showing here is these people have worked on the concentration of the total employment. And of course, when it comes to wage setting, wages are typically set at the beginning of when a worker starts working for a firm. So when they're hired, when the vacancy is opened, and then there are some interview processes and then filled. So employed workers don't get as much wages unless they're poached, unless they have outside options, or they quit or go on. So the first big takeaway is that the concentration dynamics don't exactly line up. Of course, there are many questions that are dicey here about measurement. What exactly is a firm? What exactly is the local labor market? Should we look at overall employment? Should we look at the net addition of employment? So I want to acknowledge that there are many measurement issues that we want to, should be mindful of. But in principle, what we see is output concentration and labor market concentration do not move in lockstep. So far, this is all data on the entire US economy. Now I'm moving on to my own work based on micro-level data in the manufacturing sector. The reason why I'm doing this is because in manufacturing, we have very good data on both input, output, and we can talk about productivity. We can precisely talk about what does a worker produce for the firm, what is value added per worker, and what is the wage of that worker. So standard economic theory would say, well, if there is a very good, quote-unquote, firm that gets very large, sells a lot of products, then in principle, that firm should draw resources, should poach workers from other firms, should grow, and that grows the economy. That relocation of work is essential for economic growth. This is standard thinking. And when we actually ask ourselves if that's really the case, there has to be something changing in that relationship. What I'm now showing you is a simple plot about productivity shocks or total factor productivity shocks and how firms respond to them in terms of their hiring. So the question is, do firms that have a high productivity, that are very profitable, do they also expand in terms of employment? That would be the standard way how economic reasoning works. So from this work here with Cosme Ilo and Martin Schneider, what we saw is that on the right axis to the right of the zero, the high profitability firms, they expand net hiring. The low profitability firms, they cut hiring. So that was the 1960s, 1970s, up to the early 1980s. But when you start then rolling this forward into the 1990s, 2000s, 2010s, that relationship changes. In particular, it changes at the top end. So this relationship becomes asymmetric because high productivity firms don't hire anymore. Low productivity firms still fire. So what we see is we have some of these quote-unquote superstars. They don't pass on their great profitability shocks into employment. Well, the obvious question then is, do they at least pay high wages then? Because they should pay high wages for two reasons. A, they're very profitable, they get a high TFP shock. And secondly, since they don't hire, the output per worker that remains is higher now. So in other words, talking about wages is basically nothing else. I want to mention that there's a similar relationship also about investment. So the question now is, when we think about do these firms pass on their high profitability into the wages, is based on nothing else than the question, what is the labor share? The labor share in principle, if you go to Y, which is denotes here GDP or output, L is workers, the amount of workers, and W is the wage rate. When labor productivity is high, if the market is perfectly competitive, if there are no frictions, if workers can move around and so on, then the wage also would go up because workers will compete for what they produce. However, we know that in the aggregate, the aggregate labor share, the total wage bill, WL, divided by GDP, has been going down since the 80s. So that has been documented by a bunch of papers. The interesting part is that downward trend in the aggregate labor share is actually driven by a very small set of firms. About 10 to 15% of the firms in the economy drive down the aggregate labor share. The other 80 to 85% tuck on as always. Their labor share is stable, but they remain smallish. One way to see that is the following graph. On the left side, we have again like the 1960s. This is the first year when we have data, and the right side is when 2012. What I plot on the x-axis is the labor share. So how much across firms now? This is firm level analysis. So on the axis, you see some firms that have a labor share of close to zero. That means they generate a lot of value added, and only very small fraction, like 0.2, would say, only 20% of that value added is paid out as a wage bill. And you see the thin black line is the overall distribution where firms are. You see that in the 60s, in the 2000s, most firms are actually middle-of-the-road type of firms. What is changing is how big these firms are. These are the gray bars. The gray bars denote where in the spectrum of labor shares is actually value-added economic activity taking place. And you see by the end of the sample in 2012, most of the economic activity, most of the output that is being produced is produced by these incredibly low labor share firms that have very, very high output, don't pay high wages, and they account for an incredible market share. So the question is, where does that come from? Do these guys pay low wages, or do they just generate a lot of profits? So the way we assess that is we look at the wage schedule of these firms. So in principle, we go back to the distribution of labor shares and ask yourself, how does the wage schedule look like across that spectrum of labor shares? Do the low lambda firms, do the low labor share firms, do they undercut their competitors in terms of wages? And because they're very dominant, because they operate in a very concentrated markets, and they pay low wages? Or is it because they're just, compared to their other firms, relatively profitable, but they pay the same wages as everybody else? So when we look at the wage schedule of that, this is the left graph here, you see that the wage scale, which is the light gray line, is basically almost the same across all the labor share firms. So that means there's these few superstar firms at the low spectrum of the labor share that basically don't share with the workers, don't have a low labor share because they screw out their workers in terms of wages. The way they differ is, and this is the darker gray line, is they're immensely profitable per worker. They don't share these profits with their worker. If the labor share was completely the same for all the firms, then the light gray and the dark gray line would be on top of each other, and they would be all at one labor share. But this is not the case. What the primary difference of these firms is in their output side, is in the prices. So they generate these profits predominantly by charging relatively high prices, not by being like fantastically physically more better, but they just face demand conditions that allow them to charge relatively high price, and you can see these differences are pretty fast. This is a log point difference here of like 0.4, 0.5, so that means exponent of that's something like close to twice the price for the same product in the same market at a very fine definition. Of course, there are many measurement issues surrounding this, and these firms generate extremely high profits, which they don't share with workers, but they have high prices. The reason, one conjecture, which I want to throw into the discussion, which is beyond the what's happening on the wage side, is the reason why they might not share with the workers is these high prices for a given firm, if we follow them over time, are relatively transient. So if we look over time, what's going on, these low labor share firms, please just look at the right graph, that's a bit more intuitive. These firms that have a relatively low labor share in a given year, if we backtrack them and forward track them in time, they have a low labor share for about like 5 to 8 years, and then that's it. Or because we know this is all driven by relative prices, they have a relatively good time in output markets for 5 to 8 years, and then it's over. Then they quote unquote go back to normal. That might be part of the reason why they don't share with the workers, because it's relatively temporary, and they say, well, I could either expand, I could hire more workers, but then 5 years down the road I have to get rid of them again, and that's not that trivial. I can also pay them higher wages now because they're very profitable for me, but in a couple of years I have to lower the wages again, or I have to kick them out. And so that might be one reason why they don't share. Over time, these patterns have become much more pronounced. So these relative differences of having like a couple of good years in the goods market have become, compared to the peers, relatively strong. So to summarize, there's some more evidence which will skip now. But to take away again, first of all, the concentration outputs in labor markets is not the same. It's not exactly in lockstep. And the reason is that they are high profitability firms that don't respond to good profit conditions in terms of employment as they used to. They also don't pay the wages that these workers generate for them. And the reason why they may not do that is because these are relatively transient things. The firms are engaged in a product market competition where they are relatively good for a couple of years, then they're overtaken by someone else. We see that eventually they might come back 15 years later, but there's this temporary oligopsony power which raises questions that we have to think of and how that translates into the labor market. So these are basically the 4 main points I wanted to raise and bring to the discussion. And on that, I want to hand off to Jana, who will discuss more with the labor market concentration.
Okay. Thank you, Matthias. We'll now hear from Ioana Marinescu. That's a beautiful picture.
Where is the file? Is it just coming? Oh, there we go. Sorry. All right. Okay, here we are. Good morning, everyone. I'm very happy to be here and talk to you about the economic evidence for labor market monopsony and what the role of antitrust is in all of this. And first of all, just most of you are aware here, but for some people who might be listening to us on the web, it's important to remind ourselves the broader context here for antitrust. There is a legal significance of labor market concentration because the same Herfindahl-Hirschman threshold that is being used to assess, for example, mergers applies to seller and buyer power. So one way to frame this is that for the purposes of antitrust, when we're looking at the labor market, we're looking at buyer power as one particular example of buyer power. And so in my work, in my recent work, I have been calculating HHIs for the labor market. And as others have pointed out, this raises the interesting and difficult question of defining a market. Because when you want to calculate an HHI, you want to know what the relevant market is. So our working definition of a labor market is a combination of occupation, which we define at the SOC 6, which is a fairly detailed occupational classification comprising 820 roughly occupations, commuting zone, and quarter. So for example, given that my data is going to be based on job vacancies, this would be, for example, job vacancies for registered nurses in Washington, D.C. in the first quarter of 2016. And so briefly, why vacancies? Vacancies are highly relevant for unemployed job seekers, the point being that even though there might be employment in many companies, what is of highest relevance to the unemployed job seekers is what companies have openings or recruiting right now. Hence the relevance of vacancies to understand the degree of labor market competition as faced by unemployed job seekers. So in this first paper that I'm talking about here, we are using data from Burning Glass Technologies. This is co-authored work with Jose Azar, Marshall Steinbaum, and Bledy Tasca. And this data set comprises essentially all online vacancies in the US, which itself represents more than 80% of the actual job vacancies in the economy. So using the definition of the labor market that I outlined before, which again, let's remind ourselves that's a commuting zone by quarter, by occupation, we can, for example, draw a map of the average concentration by commuting zone. And if you just look at every market defined in this way in the US, you find that 60% of US labor markets are highly concentrated, meaning that they have an HHI above 2,500 or the equivalent of 4 employers recruiting with equal shares. On average, if you take the average, in fact, there's only about 2 employers recruiting with equal shares at any point in time. Now, this situation differs a lot with geography. So what this map shows you is that the levels of concentration are very high in less densely populated areas, mostly in the middle of the country. And if you look at where we are here on the East Coast, you see a big green band of low concentration because that's where some of the most densely populated areas are. And therefore, on average, you tend to see a lower concentration, even though even there is variation. Some occupations can be highly concentrated. So therefore, because of this difference by population density, it is also the case that labor market concentration, even though 60% of US labor markets are highly concentrated, this affects about 20% of workers who work in the 60% of highly concentrated markets. Of course, for antitrust purposes, it is enough to find one market that is substantially affected, so I think the 60% is relevant. But when we're trying to explain things like the labor share, then we ought to pay attention to how many workers are affected by this degree of concentration. So the second headline finding is that higher concentration is associated with lower wages. So to look at this, we use a different data set, which is from careerbuilder.com. This is the largest online job search engine together with Monster, captures about a third of US vacancies. So using this data set, we find that a 10% higher HHI is associated with a 0.4% to 1.5% lower posted wages. So these are the wages that companies say they're willing to pay in their ads. Furthermore, people have, after we got this working paper out, it became, a whole team of other people reached out and did similar research, and 2 independent studies with different data and different market definitions confirm a negative association between wages and concentration. One paper by Ben Melick et al. And one by Rins, which just came out very recently, only a week ago or so. So this is the broad picture of what's been found so far regarding the level of concentration and the association of concentration with wages. I want to raise some issues and talk to you about how I think where we're at in terms of addressing those issues. The first one is, and that's a classic, how sure can we be that concentration decreases wages? Is it really that it's concentration per se that it is causing lower wages, or are there some other factors that the analysis hasn't accounted for that might lead to lower wages, even though concentration itself is not responsible for that? And, first of all, it's important to note that HHI is only a proxy for labor market power, and Alan Kruger, helped us see the bigger picture. And HHI can be correlated with other factors potentially unrelated to market power that also lower wages. So what can we do to, assuage our concerns that these other factors might be driving the relationship? So the negative coefficient of HHI on wages is robust to a number of controls. So first of all, one concern is that maybe labor market concentration is high simply when there are few vacancies. So when the labor market is down, there's fewer vacancies, and that mechanically could lead to higher concentration. So in our paper, we actually are able to control for the state of the labor market with a time-varying measure. We control for labor market tightness, so the total number of vacancies in the market divided by the total number of applications. And this is a very good summary statistic for the state of the labor market, as we learn from search and matching theory. The second thing we do is we instrument labor market concentration essentially by the number of firms in other markets, and this other paper by Rins also does that. The results survive there. In fact, the coefficient gets bigger. And finally, you might also be concerned that there's a correlation between concentration and firm productivity. So in this other paper by Ben Melick, they also control for firm productivity using firm data, and they still find a negative association between HHI and wages. So overall, I would summarize this as saying that these are not perfect experiments. It is very hard to find a crystal clear case of HHI being quasi-experimentally assigned, but the evidence is pretty consistent and robust to a number of concerns. The second issue, now I'm moving on to the issue of market definition. So obviously this is a tough problem that a tough nut we need to crack. What exactly is a labor market? How are we going to define it? So first, just note that even though the 3 studies I mentioned on the prior slide use different market definitions. Some use like my own occupations, others use industries, some use counties, some use commuting zone. You find a consistent negative association between wages and HHI. So the exact market definition doesn't really matter in terms of the general pattern of finding a negative association between wages and HHI. Of course, the definition will matter for the level of HHI. So if you're going to use HHI thresholds, now it really matters how you define your market because the level of HHI could be very different. To do that, and the reason why we chose our definition is we used a labor market version of the SNP test. So the intuition for this is that if the elasticity of labor supply is below some critical elasticity, the market is well defined, and otherwise it's too broad. And really the intuition for this is to say that if labor supply elasticity is really low, then firms are able to suppress wages without losing many employees, and thereby it can be profitable to do so. Whereas if labor elasticity is very high, it is not profitable to suppress wages because you would lose too many employees. And so we do have very good evidence actually on the labor supply elasticity to the individual firm. It's typically below 2. And a very recent experiment in online environments where you would think that there are essentially 0 frictions, it's super easy to find another job, even there, the elasticity is only 0.1 for an online job, right? So there's no moving cost. In principle, you can look for a job, and even there is very little reaction of workers to differences in wages. So basically, low labor supply elasticity is strong evidence for imperfect competition or monopsony, as Alan Kruger pointed out in his introductory remarks. And so if we have such a low labor supply elasticity to the individual firm, this suggests that even the individual firm, in some cases, can be considered a market in itself. It already has enough market power by itself to be a market. So therefore, an SOC6 by commuting zone by quarter is likely to be too conservative from that perspective. And so finally, the last point is how does that apply to merger analysis in particular? So the FTC already has a policy to analyze mergers based, among other things, on product market concentration, so HHI in the product market. So the question is, do we even need to worry about the labor market? Maybe these are perfectly correlated, and so if we worry about the product market, the labor market will take care of itself. But the point is, a separate labor market analysis, we think, is needed because a firm, for example, that sells in the national market can have little product market power, but a lot of labor market power in local areas, right, where it hires most workers. So in the meantime, I've done some quick calculations to get you some examples. So I've looked at manufacturing industries with more than $100 million in sales annually, so very big industries. And so an example is, on the one end, you have the car industry. There, it's relatively highly concentrated in the product market at the national level, but relative to other industries, it's pretty low concentrated for workers. On the other end of the spectrum, another example is iron and steel. Iron and steel has very low concentration as per HHI sales at the national level, but extremely high concentration compared to other industries in terms of the labor market situations that workers are facing in those different markets, where I define markets as before by occupation, CZ, quarter, etc. So I'm running out of time, so just to tell you that in my paper with Herb Hovenkamp, we discuss how labor market effects can be incorporated in a merger review using the HHI thresholds, and we also discuss the significance of anti-poaching and non-competition agreements that Alan talked about. So just last point about anti-poaching. Anti-poaching agreements are very interesting because the existence of an anti-poaching agreement establishes that, one, firms are competing in the same labor market. Otherwise, what's the point of agreeing not to poach? And two, that collusion is profitable. Because, you know, if it weren't, then again, what's the point to poach, since other firms in the market, you know, would take workers away from us anyway. So that can be a good way of going at it if we don't know what the market is, but we have evidence that there's an anti-poaching agreement. That's a good argument to use in that context. So in conclusion, we found that the majority of US labor markets, according to our favorite definition, are highly concentrated, although, as others have said, I think more work is needed in refining the definition of a labor market. We and others have found that labor market concentration is associated with lower wages, and antitrust enforcement can use this evidence and readily take into account these anti-competitive effects in the labor market by adapting existing tools that have been used for a long time for the product market. Thank you.
Thank you, Ioana. And let me take this opportunity to remind people in the room, you will have a chance to ask questions of the panelists if you wish to do so. We will have FTC staffers walking around with comment cards, so just flag one of them down and write your question on it. It will get passed up to Devesh and I, and we'll see if we can ask it. Okay, with that, we'll now hear from Nancy Rose.
Great. I want to thank you for the invitation to participate in these hearings, and I'm delighted that the FTC is focusing attention on upstream harm, whether that's from buy-side mergers or anti-competitive actions of buyers, something that I worked on during my service in the DOJ Antitrust Division. I'm proud to have been involved in the challenge to the Anthem-Cigna merger, in which DOJ included an allegation of upstream harm to healthcare providers resulting from the elimination of competition between Anthem and Cigna as buyers of healthcare services. I met with others across the administration to discuss labor market competition and its crucial role in the welfare of workers and economic growth. And I was privileged to work with both economists and lawyers at the DOJ Antitrust Division and the FTC in drafting and issuing the October 2016 antitrust guidance for human resource professionals that Alan alluded to earlier, which emphasized not just the illegality of wage fixing. There had been already government enforcement actions in that space prior to this against colluders, but more significantly, announced DOJ's intent to pursue criminal action against naked wage fixing or no-poach agreements. Those experiences motivated my contribution to the analysis that Scott Hemphill and I developed on mergers that harm sellers, which Scott testified so eloquently on during the hearing on monopsony and buyer power last month. And I thought that was an extraordinarily interesting session. I look forward to the rest of today's discussion, which focuses on one particular group of buyers, namely workers. One particular group of sellers, namely workers. I know my time management skills could use some improvement, so I'm going to start with my bottom line conclusions so that I get to those by the end. And those are two. First, I would sound a cautionary note on the conclusions that we can draw at this point from the wealth of aggregate studies of labor market outcomes. I think it's terrific that empirical economists are focusing their attention on these issues, both energizing and informing the policy debate. But despite a wave of academic research that shows aggregate declines in labor share across the economy, growing wage productivity gaps, and correlations between low wages and measures of employer concentration, either for a given occupation code or within a given industry, I think we're still a ways from being able to establish a credible causal connection between low wages and employer concentration, let alone a causal connection between low wages and anti-competitive mergers. Remember that the antitrust laws do not reach to concentration per se. They reach to concentration that is accomplished either by an anti-competitive merger or by anti-competitive, what are sometimes called monopolization, or in this case, monopsonation practices. So at least for most workers in most settings, we're still a ways from understanding what the cause of the correlation might be. And I would just urge us to recognize that without a cause, we have a lot of trouble discerning the appropriate solution. Second, so not to end on a totally bleak note, I'm encouraged by a recent empirical study by Elena Prager and Nat Schmidt on hospital mergers that suggests that there may be at least modest adverse wage effects for specialized occupations, think nurses, for example, and skilled workers within that sector who are affected by a merger that substantially increases concentration. I don't think we can yet be certain that the impact they uncover occurs from a reduction in labor market competition as opposed to a reduction in labor demand. I'll say more about that in just a moment. That reduction in labor demand could result from output restrictions due to greater market power by the hospitals, pulling back their output and therefore marching down a labor supply curve. Or it could arise from more efficient operations post-merger, again, marching backward on the labor supply curve. Those have very different implications for policy and antitrust enforcement, but I think that this study is a compelling call not only for further academic research in this spirit, what I might call hand-to-hand combat as opposed to aerial strafing over this landscape, but also for greater consideration in select merger investigations where there may be significant specialized occupations that are dependent upon labor market competition between the merging firms. So, why the caution in interpreting the empirical labor economics evidence? The first thing I would highlight is that monopsony may not be what you think it is, particularly if you're coming to this from a non-labor economics background. I learned this lesson the hard way through talking past a group of labor economists when they talked about monopsony, and I said, no, that's not monopsony. As Alan highlighted, and I think quite eloquently explained in his remarks, monopsony, as frequently used in labor economics, is not necessarily the mirror image of monopoly or oligopoly. Monopsony may be used for many deviations from a perfectly competitive outcome in the labor market, not just those that arise from having too few employers competing for workers. That's quite different than the way industrial organization economists and antitrust enforcers tend to use the word monopoly. While monopsony could be a failure of competition due to too few employers, it could also reflect, or instead reflect, a wide range of frictions, including information failures, search costs, transactions costs, unwillingness to relocate, idiosyncratic match quality, and so forth. And even when monopsony may be due to too few employers bidding for a set of potential workers, that situation may not arise from any anti-competitive action by employers, either mergers, which are actionable under the Clayton Section 7, collusion, which is actionable under Sherman Section 1, or attempted monopsony behavior, actionable under Sherman Section 2. What that means is that antitrust enforcement is going to be neither an effective nor an appropriate tool to address most of those frictions. Moreover, some of those work against the existence of, and certainly against the argument of monopsony power in what I'll call the classic I.O. sense of monopsony, too few employers, because if wages are customized to individuals, for example, then there's no effect of a merger. If each firm is a monopsonist to the workers it employs, mergers don't have any further anti-competitive effect. So I think we really need to think very carefully about how these different pieces fit together. But as I said, one of my big concerns is that we don't even know from the empirical evidence yet whether the correlations between wages and measures of employer concentration, what the implications of those are, or whether they're causally related to competition. And to explain that, I thought it might be useful to take a look at a graph of supply and demand in a labor market. So if you could just, I don't have the clicker, just flip to the next one, that'd be great. All right, so this is a little bit messy. Apologies to those of you who aren't economists or even to those of you who are. But suppose we have an upward sloping labor supply curve. That's the red curve that slopes upward. And that seems plausible. In most cases, we would think that higher wages are going to elicit more workers willing to work. With high labor demand, that's, for example, the downward sloping blue curve on this graph, wages are higher than they will be with low labor demand, the red downward sloping curve on this graph. That's true whether markets are competitive and wages are just determined by the employment level where labor supply intersects with labor demand. The label competitive shows low labor demand intersecting with the labor supply curve. But it's also true if employers are behaving monopsonistically, which is I'm representing by that blue upward sloping curve. So in either case, higher labor demand is going to be associated with higher wages, lower labor demand with lower wages. Now, why does that matter? It matters because we can't just tell, I think, from a correlation between the number of employers or an HHI of employers and the wage rate, what's going on. Suppose that we're in a market where a new employer moves into the area, shifting out labor demand, so moving from low to high. Wages go up and measured concentration goes down. The concentration's coincidental with the wage change. What's changing the wages is an increase in labor demand. Or suppose a firm shuts down a factory. Labor demand and wages will both fall, as will employment. Employer concentration will rise. We can't tell from these sets of facts or these correlations whether each employer is moving along that red labor supply curve or they're moving along a monopsonistic labor, what I call marginal labor cost monopsony curve. And I think that problem, that identification problem, which is very similar to what Steve Barry talked about in the first session with respect to concentration studies in general, I think that's a fundamental problem. It's not solved by instrumenting for HHI with the inverse of the number of firms. In the example I just gave you, it's a change in the number of firms that's changing wages and changing labor demand and changing concentration. It's not going to be solved by controlling for tightness of the labor market, because if you're on the labor supply curve, you don't have excess supply of labor. You have as many people willing to work at the going wage as is consistent with equilibrium. You just don't know how you got to that equilibrium, competition or monopsony. And it's probably not going to be solved for by a control for firm productivity. I don't want to be too harsh. IO economists ran regressions like this for years, maybe decades, making the same type of inferences from the results. And it wasn't until the late 1970s and early 80s that we began to recognize there was a fundamental identification problem confronting these types of analyses, and have adapted now to different methods to try and understand market power. But I think that's important to recognize. However, as I told you in my second conclusion, I don't think this means that we should just sit back and say we don't need to worry about labor markets. Far from it. The Prager and Schmidt paper on hospital mergers exemplifies, I think, a fruitful direction for scholars that are interested in exploring the evidentiary foundation for employment-based upstream challenges. And it suggests that mergers that substantially increase concentration may have wage effects on the order of 1 to 1.5% lower wage growth per year for some classes of workers. And I think that this study might also point at a kind of bridge to antitrust enforcement, which is they show those effects appear for workers in specialized occupations. So in the case of these hospitals, think of nurses or physician's assistants or radiologists, others that are specialized to hospital settings, as well as skilled workers. And they appear only for the most significantly concentrating mergers, changes in the HHI of 3,000 or more. Now, I think that suggests that we probably haven't missed anything in the hospital setting, because a delta HHI of 3,000 is going to get the FTC's attention on the product market side. And we don't need to allege labor market harm if we're blocking a merger because of product market harm, which courts are much more familiar with. I suspect the reason they've got observations in their study is most of those seem to be very small communities during the period when the FTC was having trouble getting courts to agree with its challenges to hospital mergers, which thankfully seems to be largely behind us at this point. But I guess I would just close by saying it's important for us to identify where we might want to add labor market analyses. So where there might be, where both firms in a merger are significant employers of the same type of specialized labor, but whose products may not be sell-side substitutes, as Iana mentioned in her remarks, or where those products may not overlap enough to hit the horizontal merger concentration threshold on the product side. These could be even potential competition, or what we've sometimes called complementary product mergers, where you might think what the firms are doing is similar enough that the employment pools might be similar, but there wouldn't typically be an immediate trigger on the product side. The reason I think this is important is that agency enforcement resources, as those at the FTC and the DOJ know well, are quite limited. And if we tell agencies to add extensive labor market analysis to most merger investigations, we should recognize that we are telling them to investigate and challenge fewer mergers overall. In my mind, that trade-off is not an obvious improvement for workers, for consumers, or for our overall society. So the question is how to target resources most effectively so we're not missing anti-competitive upstream harm mergers, but without adding an entire layer of complexity and additional analysis to all the investigations that we decide to pursue, or that agencies decide to pursue.
Thank you, Nancy. Finally, we'll hear from Bob DePelt.
Thanks for inviting me. I got to listen to everyone's comments, and I can cross out a lot of things. I agree with Nancy, so there's my overall comment. Alan and I have been going to conferences like this for 35 years or so, and Alan has a tendency to, whenever he sees a market outcome, he can think of a way to fix it. And I guess I've had a reputation for thinking that market outcomes are sort of intrinsically less fixable. Now, part of the reason I'm probably here is that I have some experience with some of the cases that have been referred to. I worked on a little bit the high-tech case, and without really revealing too much about it, as Alan pointed out, the CEO of one high-tech company called up and said, let's not poach the engineers from each other. And now, when you teach your classes, you tell your students, don't make that phone call. Just don't do that, because it's even if you think it has some pro-competitive justification, under Section 1, you're likely to be in big trouble. The real question then came down to, in that kind of a matter, comes down to, well, how much of an impact is that likely to have in practice? And it turns out, instead of, if you're trying to define the market in which people competed, the diversion ratio, if you will, for FTC and DOJ types, of where people came from and where they went if they left these firms was extremely diverse, that people came from everywhere. There wasn't that much, before the Challenge Acts, wasn't all that much mobility between these employers. They were coming from everywhere. So it would appear that the consequences of that action were pretty doggone small. But having said that, you want to tell them, don't do that, because you're going to end up with a settlement of the size that Alan referred to. So are there antitrust issues in labor markets? Well, of course, and you would think that they would be actionable under the usual criteria of collusion or unilateral conduct. I'll come back to that those kinds of things in a minute. And then so yes to that question. And then the second question you might ask is, does rising monopsony power explain the evolution of relative wages and the relative lack of success, in particular, of less skilled individuals? I think the answer to that is likely to be no. So I'm going to differ with Alan on that quite a bit. So in my view, the evidence for substantive monopsony power that might be of antitrust concern is pretty thin, both as an empirical matter and for the reasons that Nancy stated. Though I'm pretty skeptical of Iona's evidence, and I'm going to come back to that in a minute, suppose for the sake of argument that she's right, that in all those red places on the map, they're kind of red politically and they're red in her map because they're highly concentrated. In these narrow occupations, employers possess some monopsony power. then the operative question is, well, what do you want to do about that? How should the FTC or the DOJ concentrate or use their resources in these cases? And it's true that you might want to be alert to the possibility of anti-competitive conduct in there, but as Nancy pointed out, merely the possession of some market power, which would here be a small elasticity of labor supply to an individual employer or a group of employers, is not actionable in and of itself. The possession of market power is not an antitrust violation. There has to be some anti-competitive conduct that goes along with it. So you treat it much the way you would treat any other case. It's just kind of Stigler's theory of oligopoly applied to labor markets. There are some plus factors, and if you've got scarce resources, you might want to devote them to places where you think anti-competitive conduct might arise. Now, Alan might argue that the putative existence of monopsony power in those red places is a reason for offsetting monopoly power in the form of unions. And I don't think that's it's certainly not an antitrust concern. And the other thing to note, though, is that unions have typically been less powerful in exactly those places. And if it was really a monopsony, and those patterns have existed forever, if it was really monopsony, you expected those would be the places where unions would be most successful. Now, Alan makes much of the existence of franchise agreements and restrictions within franchise agreements. And I got to read your paper yesterday, so I'm going to comment a little bit on that. And some of your comments sort of indicated that, well, I can't think of a really pro-competitive reason for doing this. Now, if I started Bob's Excellent Hamburgers and I had 2 franchises, I would probably tell my franchises, I don't want you recruiting from each other. You're competing in the labor market. Why do I want to do that? Because brand name matters a lot. And I'm going to have all kinds of vertical restrictions on what people can do and how they can fix the hamburgers and how the store is going to look. And one of the things I want my employers to do is go out and find people. And going out and find people is hard, especially in a business like that. I used to work in a grocery store, and one of the things I learned is that 90%, applies to a lot of things, 90% of success is just showing up. And you want to find the people that are just going to show up. That's an investment in individuals. And if I allow my people to rate each other, my franchisees to rate each other, there's going to be a lot less incentive to invest in that form of human capital. It's not the type of specific human capital we usually think about, but it's really important. Does that have much anti-competitive impact? No. And I read Alan's evidence that a lot of franchises do this as more evidence that this has got to have a good pro-competitive reason. Small firms do it, small franchises do it, large franchises do it. Now, can it have some anti-competitive impact? If you can prove that McDonald's is a valid labor market for antitrust purposes, then it might. So you've got to weigh, as always, the anti-competitive effects against the pro-competitive effects when you're talking about unilateral conduct. Now, let me come to just discuss briefly some of Iona's evidence that, sorry, Iona, I'm not buying. And let me find my notes here. So if you'll recall her map, we don't need to put it back up. We had red states and green states. And one of the examples I used to give back when we were talking about efficiency wages and people saying, well, some firms pay much more than others, is if you think about the market for economists. And there's out in Lincoln, Nebraska, which would be a commuting zone, there's basically one place where professional economists can work. And the Herfindahl is going to be really doggone high. And if you go off to Boston, it's going to be really low. Well, the average productivity of the economists in Boston is substantially higher than the ones in Lincoln, Nebraska. And so you're going to expect wages to differ in that regard. So my point is that a lot of that differences that you see simply have to do with the composition, even within the skill composition, even within these groups. Now, in reality, that picture doesn't have any impact on Iona's real evidence. She has that picture that shows that those markets are more concentrated, the red ones out in the Midwest, or out on the plains are more concentrated than the ones in Chicago and Boston and around San Francisco. Do you kind of expect that? And then she's got a graph showing that wages go down as concentration goes up using that cross-sectional evidence. But the evidence you really use is changes within. And it's worthwhile keeping in mind that she's got data from 2010 to 2013, which is a very short period of time. And she runs her regression because it's got fixed effects. You're only using the within commuting zone variation. And what she finds is that for OLS, changes in that concentration have a small impact on wages, about 3%. And as Nancy pointed out, a lot of that can come from the fact that when another firm enters, you've got greater labor demand and wages may rise, especially because this is a short-run elasticity. And then and by the way, how big is that 3%? Well, the mean HHI in her data is about 3,300 or 3,200, something like that. And a change in the log of 1 is going to be 2.7 times that. It takes you up to almost pure monopsony. So that would be a huge change, and it gives you 3%. If that were the impact, it would not be worth the attention of the antitrust authorities to go chasing that. On the other hand, she has an instrumental variables regression where the impact of a unit change in the log of the HHI is on the order of 11 to 14%. Now we're talking about something that might matter. On the other hand, what is that instrumental variable picking up? The instrumental variable is itself the change in the number of firms in a lot of other places. And so the regression that she runs is how much of the within this area change in the HHI is explainable by changes in the number of firms being created in other places, which is to say you're picking up aggregate demand effects, and those are much likely to be much larger. So the argument that these findings are due to monopsony power strikes me as pretty doggone weak. So I'm going to leave my comments there, and I look forward to our discussion.
Thank you, Bob. Okay, we'll now move on to the Q&A portion of our panel. And once again, let me remind those of you in the room that there'll be FTC staffers walking up and down the aisles to collect any questions we may have from the audience. Okay, I'd like the first question to go to Joanna. Joanna, Nancy, and Bob both expressed some skepticism of the current state of research, including your own papers, of course. Nancy sounded a cautionary note that we may not be there yet in terms of having a causal connection between concentration and wage. Suggested that concentration is not necessarily of direct relevance to antitrust, given what we have control over and what we don't. Bob suggested variation between Lincoln, Nebraska, and Boston, Massachusetts might be explaining some of the results that you find. Would you like to respond to any of this?
Yes, I'd love to. Thanks so much for your thoughtful comments, both of you. So let me start with Bob's points. As Bob accurately pointed out, our regression does not rely on comparing Nebraska with Boston or Chicago, but relies on changes over time in the HHI within a given market, namely an occupation by commuting zone. So that's the variation. Now, it's true that this could still be driven by labor demand, as both Nancy and Bob have pointed out. And what we do is control for labor market tightness, and that, I understand Nancy's point. I think in the end, what you should control for and how to interpret it depends on your specific model. So, for example, under perfect, competition, workers indeed will also be less likely to apply if wages are lower. But we've seen that the elasticity of labor supply is very low. So if that's the case, tightness will not react much on the worker side, might react on the firm side. But this is something that in any case needs more investigation, and that's why I've started, Steve Barry in the same hearings made a similar comment, and we reached out to him, and actually we're starting a paper together, trying to do better on that front by using some of the tools that IO has developed in the meantime to address precisely some of these issues. So stay tuned. Hopefully we can do better there. Now, there's another evidence that There's another point that Bob made, which is regarding the IV. So it is true that it could be correlated with, again, labor demand at the national level. One thing we do is that in our OLS, we can control for occupation by time fixed effects, thereby absorbing certainly national change in labor demand for each occupation. And that doesn't affect at all the effect of our concentration in the OLS. So it's just one particular way of controlling for time-varying changes in demand at the occupation level. So this is reassuring, but granted, it's the usual discussion of omitted variable bias. It's a little bit hard to be foolproof there. So
let me just clarify something about that. In the IO estimates, you're using the portion of the within region or within commuting zone variation that's predictable by the national changes. So that says that this part is predictable by what's happening everywhere else. So what you'd expect to find is that the idiosyncratic parts that allow people to move across areas is going to have a small impact on wages because people are mobile. On the other hand, if everybody's moving together, you'd expect a larger wage impact, and that's exactly what you get.
Right, and in the new version of the paper, we do a bounding exercise, which I'm not going to bore you with, but if the variable, the instrument is partially endogenous, there's a way to give bounds, and we find that even if it's quite endogenous, we still find the negative effect. Of course, the magnitudes change. Now, what we can bring to the analysis is rely on the new analysis by Prager and Schmidt, which I think is fascinating on the mergers in the healthcare industry. And there, the nice thing about their work is that, as Nancy pointed out, we're using these HHIs everywhere, which is kind of nice in a way because we're capturing everything. But the big downside is that we can't really account for what's truly going on. Why is HHI changing in a given market? Who knows, right? So that's a problem. And in a study of healthcare mergers, like the one by Prager and Schmidt, at least we can have a better handle on what's really going on, what's causing these changes in HHI. And I think their study is quite nice because it's able to do a good job, I think, of accounting for some of these demand effects. For example, they look at whether there are pre-trends in wages before the merger happens, which might happen if there was a demand shock that occurred prior to the merger, and they don't find any evidence of that. They also looked at the effects on wages of out-of-market mergers. So mergers between companies that don't, happen to overlap in markets. Those mergers don't have an effect on wages. Or the effect of mergers that were blocked. Also no effect on wages. So I think this is somewhat reassuring that it is not some labor demand shock that is driving the effects that they are talking about. So I think that's about it. Thank you.
So this is to Alan and Bob. So imagine you have a policymaker that's concerned about either the falling labor share or the stagnating wage. How would you rank the different policy tools that might affect these, and where would antitrust enforcement, either on conduct or on mergers, rank in the list?
Bob, you want to go first?
The question was for Alan and me?
Yeah, but
And the question was, what policies will affect labor share?
And wages.
And wages? First of all, I'm not convinced that labor share is the thing we ought to be looking at. I mean, there's often been a lot of confusion about the decline in labor share and a change in welfare of workers. If for example, the price of capital declines, that there's some evidence for, or at least prices of certain types of capital declines, or if there's capital bias technological change, which is equivalent. And if the elasticity of substitution is a little bit above 1, you'll get a decline in labor share of national income, but there's more capital, and the workers get more capital to work with, so the marginal product of labor is going to rise. Now, it's true that might take a few years to play out, but simply a decline in labor share of national income is not an indicator of welfare or monopsony power or anything like that. So would I want policies that are targeted at labor share? No.
How about wages?
Are there policies that could affect wages? Sure.
That was his question?
Okay. Yeah, what would happen to the wage, to people say at the bottom of the wage distribution? Well, in my view, a lot of what's happened is that is due to skill bias technological change that's been very disadvantageous to people at the bottom of the wage distribution. Interventions there are likely to make human capital even more scarce than it was before. One solution would be an immigration policy that put more emphasis on changing the skill ratio itself, because that's been a big disadvantage to less skilled people.
Why don't I respond a little bit more generally to what Bob said earlier, as well as answering the questions. I agree with Bob on labor share. I think if we focus on policies to raise wages, that will probably end up raising labor share. In the short run, having a strong macroeconomy seems to be the best advice. Of course, you don't want to overheat the economy and have another crisis like we had 10 years ago. But since the work of Arthur Oken on a high-pressure economy, that seems to help people, particularly at the bottom, over the long run. I agree on human capital investment, preschool, help for post-secondary education, and so on. I think there's a lot of common ground between Bob and me in that we both would like to see a competitive labor market. I think the difference is I have my doubts about how competitive it is to begin with. In fact, the graph that Nancy showed with the upward sloping supply curve, to labor economists, that's actually quite controversial, in that the explanation for industry wage differences is that there are different supply conditions to different industries. We don't have the law of one price. And the model that you graphed, you've got very different markets for homogeneous labor. That's the way I was reading what you showed. Or in any event, labor economists will call anything where there's an upward sloping labor supply curve monopsony. It doesn't matter to us how we got there, because you get monopsony-like effects, which is why Alan Manning called his book Dynamic or Monopsony in Motion, because the search frictions give individual firms upward sloping supply curve. And in that kind of an environment, the existence of non-compete agreements and no poaching agreements can have an effect on wages, where if you start from a model where you've got an infinitely elastic labor supply curve, which is the competitive model, those agreements wouldn't really matter because workers are just paid the same wherever they're working. Bob, I think unfairly, said that I look for government interventions to solve these problems. Some are no doubt beyond the reach of antitrust policy. I haven't been an expert in any of these cases, so I don't have the insights that an expert might have. I also don't have the potential conflicts that an expert might have.
I was teasing you, Alan.
I wasn't referring to you per se.
You said unfairly. I was teasing you.
Oh, okay. Anyhow, in some of these cases, it's pretty clear what the loss is to the workers. If a hospital reaches out because they have vacancies, because they've colluded with other hospitals about hiring, and they pay $40 to temporary nurses, and the staff nurses are paid $30, that suggests that the marginal product of the nurses is at least $10 higher. I agree that in some situations having bilateral monopoly would be a better solution, having more labor unions. I agree with what Nancy said about antitrust having to think about how to use its limited resources. I also wonder, and I don't know how common this is since this is not my field, if you have a case which is on the margin on the product market side, if the labor market side could put that over the top, that if you take labor market side in addition to the product market side into account. So it could potentially end up blocking more mergers that are harmful to workers and to consumers if the labor market side is added to the equation as opposed to focusing exclusively on the product market side. And I'm a bit confused about Bob's argument on Steve Jobs, who told Google, if you hire any of my workers, this means war. That Bob would recommend that that's not a good thing to say, and it's not a good practice to put in place. But then when it comes to no poaching agreements, he said they're fine. They could be in contracts. And the argument that Bob gave about the brand value, I think, is an argument based on anti-competitive rationale. You want the franchisees to hire good workers, and you want to pay them less than they could get elsewhere, and you say to them, you may add value to our brand, but the only place you could go is outside our brand. We're not going to let you go to another establishment within our brand. So again, I'm not an expert in these cases, but I would think that that's an argument that this is an anti-competitive practice rather than a business justification that would pass muster under the law.
I'll just say that you were unfair there, but let's keep going.
Okay, next question. Bob just said,
Could I wait, since I'm implicated in Alan's remarks, do you mind if I weigh in on that?
sure.
So two things I wanted to say. So first, working in reverse order, 2 weak antitrust cases do not a successful challenge make. So I think if the question was, is there a strong labor market case and a product market case that might not be as strong? And that was why I gave it the touched at the end about maybe a potential competition or a complementary product merger where it's very hard, as the FTC knows well, to successfully challenge on potential competition grounds. If there were a strong labor market case, you might bring that challenge and bring it successfully. We don't know because courts have not yet decided a merger, even on a buy-side, a litigated merger, even on a buy-side harm that doesn't involve labor market but other suppliers. We don't know how they'd respond to labor market. It would be a challenge. It's probably one that's worth exploring and testing and developing. But to say, you know, if the product market's at the margin and the labor market's at the margin, I don't think you bring that case because you have the potential not only to go down, but for bad law to be made as well.
Okay, next question. So Bob just said that in his view, the labor share doesn't really matter, should not be a concern of policymakers directly. Yet, Ioana's work, the Ben Melick paper, and the 2016 CEA report on labor monopsony all cite the declining labor share as a motivating fact. So let me read from Marinescu and Hovenkamp. Quote, the share of GDP going to labor has been declining at an alarming rate. This may result from several things, including suppression of unions and increasing concentration in product markets, but lax antitrust enforcement could be a major source as well. So first question is, should we care about the declining labor share? And the second question is, well, Matthias just presented results that suggesting the decline in labor share is due primarily to a reallocation of production to superstar firms. And that seems to me to be a explanation that is perhaps orthogonal to antitrust. Would you agree with that characterization? And do Matthias's results cause you to update any priors about how concerned we should be about labor market monopsony? So let me ask Ioana that question first, and anyone else that wants to weigh in can do so.
Right, so this evidence has been coming up between when I wrote this and now. We've had more evidence, for example, about trends in labor market concentration, which we didn't have at the time. And with my vacancy data, it wouldn't make sense to look at long-run trends because the vacancy data has changed so much over time. So, you know, I still think that this needs more research, but it is fair to say that right now with the kinds of data that people have used based on employment concentration and typically at the industry level, there has been a decline in labor market concentration, and therefore it is not as clear how exactly this plays in the trends. So, you know, to what extent labor market concentration trends, not levels. I think I want to make a distinction between that, you know, explains wage stagnation. But, you know, here's some interesting avenues, I think, for future research. So first of all, again, labor market definition is critical. And one issue when you compare over time is to ask yourself, is the definition of the labor market, should it stay the same over time? And that is a critical question because, for example, we've done some preliminary analysis looking at the impact of population density on the scope of geographic search of workers. So basically in more densely populated areas, commuting times are longer, there's more congestion, and people tend to search closer to where they live, for example. And that's changing over time, differentially over different zones. And so after you adjust for that, for example, the decline in HHI doesn't seem to be as strong. Just as one example of issue that needs to be addressed in terms of thinking about the definition of the labor market. Other things that might be interesting to think of are things like multi-market contact or changes in common ownership. So, I believe that we need to learn more about the trends and how the whole, story fits in. I feel more confident about the general relationship between concentration and wage, or, even to be less controversial, market power, because I think the labor supply elasticity evidence is much stronger, better identified than the concentration evidence. So I think there is an issue of market power, and that it's very clear that there is such an issue of market power in the labor market. But exactly how the trends have played out, I think at this point is less clear, and we have to further investigate to learn more about that.
Sure. So does anyone else want to comment on whether we should care about declining labor share? Matthias?
Yeah. Sure, I'm happy to talk about this. So in principle, when we talk here about wages, and this is not the point it's not about wages, it's about welfare. And when we think about welfare, we have to think about what is your wage and what is the price level. So it's really about real local wages that we should be concerned about. The labor share gets us a little bit closer to that because it relates the wage to the nominal output, or the share of that stuff. When we started our research on the labor share, we tried to come up for reasons for why the labor share went down. We explored about half a dozen of avenues related to labor market factors in the hope that there was an explanation. So we looked at states that become right to work. Is it that now there's lower bargaining power that we see actually the labor share declining in those states? And the evidence is basically very muted. We also looked at regions where unionization has been going down a lot. Basically, manufacturing has a bit exodus from the Rust Belt, Midwest, down south, where wages generally are lower, the regulations are lower, they have much more free reign. Boeing is shifting production from Washington to South Carolina. All car manufacturers have plants in Tennessee, South Carolina, Alabama. We don't see a big impact on the labor share. We also looked at concentration. See, basically Walmart comes to the county. Does that lower the wages a lot in that county? And the evidence, again, was pretty muted. So the labor share, we have basically a paper where there's a big graveyard section at the end, where there's like all these unsuccessful hypotheses that empirically don't really hold up. It took us 2 years of testing to find out that actually the main action is at the output side, at the price side. So this is, in terms of labor share, the one thing that we have to understand in terms of when we think about this in the context of the labor market, we have to think, what does it mean for the consumers, for your real purchasing power of the wage that you have? And that is one thing that I wanted to add to the discussion about local concentration. So there are two things. Labor markets are regional. They tend to be regional. You have a certain set of pool of people that live there and a certain pool of employers that hire there, and that's it. Goods markets are not. So when you consider antitrust cases and you consider the labor market consequences, that is very hard to assess because we have to basically keep in mind that firms' action, they're active nationwide, but in the local market, they act locally. So that's one aspect. The second aspect I want to say is, what is the difference between concentration at the local level and at the global level? So locally, it might well be that concentration is going down because a new employer moved to town. But if basically we know that at the product level side, there has been a lot of consolidation. So if it is the case that basically if you live in county A or commuting zone A, and your options are work for Walmart, become a Starbucks barista or something else. In the old days, you used to have the option to pack up and move elsewhere, and you would face different employers, different firms. Today, you again have Walmart, Starbucks, and some other local firms. So basically, these firms, when they set their wages locally, they keep in mind, they set a whole menu of wages not only just in that one commuting zone, but also in the neighboring regions. So that's important to keep in mind to assess the whole situation about local concentration. What are the other options for the workers to go elsewhere, and what are the local prices? Oh, and to add also the last thing about the labor share, what Bob Topol said earlier, the story that capital deepening is behind the labor share decline is also not the case.
No, I would have described labor share as a symptom rather than the cause. And Matthias showed before that there seems to be less profit sharing, less rent sharing, or less sharing of the gains in productivity at the superstar firms. Another development which is consistent with that is the firm size premium is smaller than it used to be. So larger companies used to pay higher wages, and that gap is much smaller, which is consistent with a weakening of worker bargaining power. The places where there are rents, where workers could get a bigger share of the pie, they're not able to for whatever reason. Some of those reasons are well beyond the reach of antitrust policy. Some antitrust policy may be able to have a significant effect. If the October 2016 guidelines are enforced, and so far I'm not aware of any criminal cases, that could send, I think, a very strong signal across many different employers. So I think of it more of a symptom, and one of the causes may have been weakening bargaining power related to anti-competitive practices.
So I want to echo that, but Alan, I don't know why you're going to anti-competitive practices, because it seems to me, having in my youth worked on rent sharing, and hearing some of the discussion that you've had here today, that weakened worker bargaining power may be due to a whole set of institutions on the labor market side that really have nothing to do with competition among employers or with antitrust. And I would have thought, if we were trying to choose an answer that required kind of the least steps of logic to get there, that would be the place to begin. I mean, we certainly have, as your earlier remarks indicated, a lot of evidence that there's been a decline, say, in not just unionization rates, but union bargaining power as a consequence of that, more difficulty in unionizing firms and so forth. And I think this discussion of worker rent sharing also weighs into that. What we're asking for, if we think that rent sharing created a kind of golden age where workers were paid more, I'm not saying this as a former antitrust enforcer, but we want less competition, not more, to get those rents created and then shared with workers. And so I do feel we're chasing after a bunch of symptoms that make us concerned. And somehow, for some reason, we've glommed onto antitrust, but it is neither, as I said before, the most effective, nor appropriate, nor probably legally available tool for a lot of what we're concerned about.
Let me respond a little bit. I think that raises a very important point. I don't think they're independent. I think the decline in unions helped to lead to some of the anti-competitive practices, that it's harder for employers to require non-compete agreements. If there's a labor union which is negotiating a contract and says, we don't want a non-compete agreement. It's harder for companies to have anti-poaching arrangements if franchises are unionized. So I don't think that they're independent. And I don't want to argue that the significant changes we've had in the labor market have developed because of increase in anti-competitive practices. I think that's a contributing factor. I think there are others which may well be more important. So I don't want to mischaracterize myself in saying, this is the instrument that we should use because this is the problem. On the other hand, there are very few instruments that are available currently. So if you say, what are the tools that we could use, especially if they've been underutilized, which I think has been the case, that the franchise contracts have been allowed to have no poaching agreements for decades. It's only recently, because of the actions of the Attorney General in Washington State, that 30 franchises have dropped it, affecting hundreds of thousands of workers. So I think these are tools that were in our toolkit that were underutilized, but I don't, and they're available, but I don't think they are, I wouldn't necessarily, I think we don't know enough to say that anti-competitive practices are the main reason, and I suspect it's probably not the case.
So this is actually a nice segue to my next question. So this is about the definition of monopsony. So maybe one of the classical definitions of monopsony would be you restrict the amount of labor hired, and so the amount of output generated, and then there's going to be a welfare loss of deadweight loss in the output market. But you could also think about things like a change in bargaining power between labor and management, and workers are now getting a smaller part of the joint surplus from their employment. So should we be, as antitrust enforcers, be worried about changes in bargaining power? Is that an antitrust concern or not?
So I'll say yes. I've got a Yale Law Review paper with Scott Hemphill that says absolutely yes. I think the antitrust law requires us to focus on actions that reduce competition, and if we're reducing competition, and that's what's leading to sort of reduced or increased employer bargaining power, say, and an ability to suppress wages, we should worry about that if it's coming from a merger, say. If it's reduced bargaining power by workers because we've become more hostile as a country to unions, that's not an antitrust, that's not an anti-competitive effect that's coming through action of the firms. And that's probably not something that we can reach. But I think the notion that we need an output reduction as opposed to transfer of wealth is very misleading. We don't do that on the product market side typically. And so I don't think we should be doing it on the input market side either. Bob may disagree.
No, I agree with what you said. If it's due to a reduction in real competition, then it's an actionable thing. It's within the purview of antitrust policy. If it's due to other phenomena, you referred to hostility, but there's a lot of reasons why the decline in the fraction of labor force that belongs to unions is. Yeah.
Oh,
no, I'm not suggesting that
it could be anything,
it could be anything, but none of those really fall within the purview of antitrust policy.
Okay, next question. So speaking as an antitrust enforcer, I mean, to a first approximation, we block mergers if we think the price is going to go up. A merger that might increase employer concentration, we would think, cause wage to go down. If wages go down, the price of the product purchased by consumers may go down as well. And so one, is it clear that, what is the path to address concern about labor market consolidation from a merger if it would cause product market price to go down? And two, how would we balance a merger that might increase labor market consolidation but have other efficiencies that would cause the product market price to go down? And so that's probably most appropriate for the antitrust people with antitrust experience, so we can start with Nancy.
Sure, I'd love to weigh in on that. So I think the first and most important thing to keep clear, and I'm not saying that you weren't recognizing this, but I think in these discussions, particularly among antitrust practitioners, if it's a classical monopsony case where the firm is withholding employment to drive the wage down, the firm does not perceive that lower wage to come with a lower cost of hiring a worker. If you go back to that curve that I showed you, the firm is perceiving the marginal cost of hiring another worker to be very high because it has to pay a higher wage to everyone. So in a classical monopsony case, there's just an output restriction by the firm that's exercising monopsony power. There's no lower cost to pass on. In the bargaining case, that might not be as apparent, or it might not be true. There might be no employment effects, no output effects, just a transfer of rent, but a transfer of rents from workers to the firm due to, say, an anti-competitive merger. And as I said before, our merger law requires us to challenge mergers that may substantially reduce competition. I think it's misleading to say, how should we balance? It's like saying there's a merger in the product market that has product market benefits for some set of consumers or some set of products or purchasers, and it has harms in other product markets. Should we say, well, let's add them all up and say, if the total is that the group that wins by more than the group that loses, we just let it go? And I don't think we typically do that. I think if we see that there are, of course there's always prosecutorial discretion, but if we see that there are a group of consumers that are harmed by an anti-competitive merger, we challenge. It might be that if the merger's got mostly benefits and there's one small group that's harmed, we accept some kind of remedy that solves the competitive harm and preserves the benefits. But I don't think we tend to agonize over that balancing in the product market side, and I don't think we should agonize over that balancing when the harm is going to workers.
Yes, and actually in my paper with Herb Hovenkamp, we discussed this point and come down to the same conclusion based on case law.
So next question. So for better or for worse, whenever we're doing an antitrust case, one of the basic things we need to do, and which is often kind of the biggest part of the legal case, is antitrust market definition. So in terms of labor markets, how should we approach geographic and product market definition? And in particular, this is a point that Bob picked up. If you think about the market for university professors, Lincoln, Nebraska is probably not a market. The market should be maybe more broad or more national. So how much labor mobility do we need in order to define a broad market versus a narrow market?
And over what period of time does mobility have to, or that elasticity have to occur? I think that's really an important question.
So as I was outlining in my presentation briefly, one of the tools you can use is the critical labor supply elasticity, and this can vary by occupation, right? So I think that's what you're getting at, that different types of workers might be more or less mobile. And this is something that we actually are able to get data on through various sources, including, for example, transitions, say, from the current population survey across geography for different occupations. In my current work in progress with Jose Azar and Steve Berry, we're using a very detailed micro data set of applications from workers to jobs where we have every occupation under the sun, and we see the distribution of applications, which kind of allows us, by occupation, to see the variety of geographies and other types of jobs that people are applying to. So there definitely exists ways of getting at that if we're interested in estimating those elasticities, and this is something that we are actively working on.
Yeah. Just to add, as a practical matter, labor markets tend to be more regional for less skilled workers, more national for highly educated workers. It's going to vary a bit by occupation, but that's what one generally finds. And we do have data available to do the kind of analysis that Yona was mentioning, to look at where workers are moving, how are they defining their markets, and use that as an input, I think.
So are mergers that lead to worse outcomes in labor markets more likely to involve high-skilled workers or low-skilled workers? I mean, it seems to me like low-skilled workers have maybe different occupations that it would be easier to shift occupations if you're low-skill, but if you're high-skill, you're likely to be, when I was a professor at University of Kentucky, the nearest comparable employer was like 75 miles away. I couldn't really go anywhere, so it seemed like I was more locked in as a high-skilled worker there than a low-skilled worker. Maybe I'll post that to Nancy.
So I wanted to weigh in. When I was thinking about what mergers might we have missed, and I have a candidate, the candidate popped in first because the second most highly concentrated occupation in Iyana's work was, in one of her papers, was rail car repairers. And that called to mind an April 2018 DOJ no-poach action against rail equipment manufacturers, Knorr, Brems, and Wabtec, that alleged that the companies had, quote, for years maintained unlawful agreements not to compete for each other's employees, and moreover had a similar no-poach agreement with Favely Transport before Favely was acquired by Wabtec in November of 2016. What this no-poach complaint said was that they'd entered into what they called pervasive no-poach agreements that spanned multiple business units and jurisdictions, involving, typically it said primarily affecting recruiting for project management, engineering, sales, and corporate officer roles. So I wonder if sometimes we have some indication of what these labor markets might look like by the extent, when we uncover a collusive agreement, by the extent or the incidence of where the no-poach agreements are being pursued. And that does suggest a more high-skilled occupation mix. Maybe not as specialized as I would have expected it to be, but it doesn't sound like they were entering into no-poach for the janitorial staff or even the low-level factory workers, suggesting that maybe we worry more about that. Typically, again, not always, we'd have to look at facts and circumstances, but maybe more with the higher skilled or more specialized workers. And that's certainly consistent with what that hospital mergers paper found.
And you know, that just gives you the easy way out in the sense that if there is the no-poach agreement, that's a very good piece of evidence to use. You don't necessarily need to, I mean, or at least the further evidence would be confirmatory instead of having to dig deep into the elasticity of labor supply for that particular, you know, kind of occupation.
Well, let's be clear. If you were going to challenge the merger, this might be a useful screen. You're not going to win a merger case by just saying, look, it must be a labor market. They had this agreement here. I think anybody who's been involved in litigation would be leery to go to court with just that argument.
Putting aside collusive conduct, do we have good examples, like in the realm of mergers? We have all kinds of examples of possibly mergers for monopoly that can be challenged because it's going to affect prices in the output market. Do we have any examples of merger for monopsony where the purpose was to reduce wages in the labor market? Or are we chasing unicorns here?
You know, it's interesting. I'm not sure there's an answer to that. And on the chasing unicorns, when the October 2016 guidance was discussed, that very same question came up about, well, how common are these no poaching agreements, wage fixing agreements?
But that's the collusive
let me
side,
just
yeah.
finish, Bob. And the Assistant Attorney General, Melick Delverheim, said he's been shocked by how many cases there are. And part of the guidance set up a hotline for people to call in. So I think, you know, I started my remarks by saying this is an area where I think we're learning a lot, where there's been a lot of active research. I don't think we know the answer to that. But in some areas, it looks like the anti-competitive practices are more common than was widely understood.
So I think it's harder to get that information on the labor side, but it's not impossible, right? So when you start a merger investigation, you're calling and talking to people in the industry, and you're often getting inbounds. And so I think if there was a merger primarily motivated by an effort to push down wages by the two merging parties, I'm not saying for sure we'd hear about it if it really affected kind of lower level workers, but if higher level workers thought, you know, this makes no sense except that it's going to really eliminate the only people competing for my talent, I would have thought we'd hear some about it. I suspect it's not the main or only motivation, but there could be mergers where, so like in this rail equipment one, where maybe the labor market overlap is more significant than the product market overlap was.
Well, you can envision a lot of mergers, let us say for efficiencies, that end up being labor saving, that because of, at least for the short run elasticity of supply that Iona refers to, there's going to be a large impact on people who've got specific skills to the firm and stuff like that. So that labor costs might decline a lot, and it might not just decline because of a head count, but because you have to pay these people less to retain them. So then you've got to balance anti-competitive impact against pro-competitive benefits. But I'm asking about one that would be specifically like, look, we're not going to be more efficient. We just, in terms of the diversion ratio, we've brought this other unit inside, and now we can control the price better than we did before, but the price we're controlling is on the labor market side.
So Bob, would it be anecdotally thinking about the high-tech sector, we hear about companies buying another company in order to get their software engineers? So, that's only anecdotal. I don't know, how much evidence we have on that, but at least you hear those stories regarding, buying the pool of.
Well, that comes back to high tech. I want to hire the software engineers from the guy across the street because they know a lot of good stuff that my folks don't know. So that's more like proprietary information I'd like to get my hands on.
Another example was the film animators, Lucasfilm and Disney, which had a big settlement for no poaching. Then they merged. And it's a little hard to say that they did it to get the, human capital before they agreed not to poach from each other.
Right, although there you would want to investigate sort of what the labor market looked like, right? Was there something about these two firms reaching an agreement, but there were lots of other competing employers or not?
I don't think they were.
I see. I mean, I think that's the kind of thing that antitrust enforcers know how to do. I think what's great about this literature and this discussion and these hearings is that it's maybe encouraging us to ask some of these questions early on in an investigation to determine whether this might be one of, maybe it's not a unicorn, but maybe it's one of the rare ones where labor market issues might come to the front.
So if you look at the research, we talked about a lot of research today, and if you look at the dates of those research papers, they're 2017, 2018. So this is a very new field. And so what kind of evidence would you like to see developed on the antitrust relevance of labor market monopsony? Is there a good way to try to get causal variation in monopsony power, and kind of what research needs to be done that hasn't been done yet?
It's interesting. I think about this totally different than IO economists. So what I think we need are good demand shocks to firms so we can estimate their labor supply curve. Iona cited, the Manning estimate of the labor supply elasticity, and I cited one by Weber. But that's one where I think we could probably use more compelling evidence. Now, to us, it's news. To labor economists, I think it is news that firms face upward sloping supply curves, because that's not the standard model that we use. The standard model that we use is law of one price, infinitely elastic supply. So that may be of no interest to antitrust or IO economists, but to me that, I think, is a priority for research.
Right, but for antitrust, it's not just...
It's not for antitrust.
Right.
One of the, I'm unburdened by not having been a witness and not being an expert, not being an IO economist. I think for understanding the way the labor market works, which sets kind of a milieu for thinking about where anti-competitive practices can occur, I think that's a really important first step for us. That the mindset is still one, largely, although it's beginning to change, where it doesn't matter if employers collude because they can't affect anything. The market is so competitive. The practice is not going to affect wages.
And how does that get squared with all of the work that, for instance, you did in your youth on inter-industry wage differentials and rent sharing and all of that?
Well, that's why I think it's a much better way to think about the labor market. But I think we're kind of at a turning point now where there's a lot of movement in that direction. But I think it's a turning point rather than a new day.
Can I say something? Alan, you are actually thinking like an IO economist, because the first thing on the list when people start thinking of what's the likelihood that a collusive agreement might succeed is that demand is inelastic at the competitive price. And so you want to know something about it, people's ability to substitute. You want to know about the elasticity of demand. All you're saying is, I want some movements along a supply curve so I can figure out what the elasticity of supply is. So and the operative word that you just mentioned is potential. That if demand was huge, or if supply was hugely elastic, you'd say, look, attempted collusion here is attempted murder with a wet noodle. And you just wouldn't go after it. But I don't think that the steps you'd go through are any different on the supply side than they are on the demand side. It has nothing to do with labor either. It could be any input you want to be using.
How do you square that with, say, the vitamin cartel or other commodity cartels?
I don't see the contradiction. I'm saying.
Well,
that-
where I
oh,
would
you
have
mean
thought the demand was, for a firm, was pretty darn elastic, but we saw collusion. I'm
No,
just,
but the question is, no, it's whether the market price is inelastic at the competitive price, which means that there is a big return to restricting output and raising price to everybody. And that's the first thing on the list when you start thinking about these so-called plus factors. And it'd be exactly the same thing on the labor market side.
Just to weigh in on what type of research do we need for this? I think typically people either use worker level data or firm level data. But I think it's actually important not just to look at the wage level, but also at worker flows and who works for whom and how long and where do you go. That means you have to work with match data on where workers and firms show up in the same data set. And that's something that's, at least in the US, I find quite limited. There are some other countries that have much, much better access to match data where we know much more about these worker flows and the incidence of different shocks, the incidence of mergers and so on, and what happens when wages go down here, what do workers do? In the US, we don't know that so well because the worker side of the information typically comes from state unemployment records, and some states are extremely reluctant to allow the federal agencies to use those data. And if there's any way maybe to remedy this, then we would know much more about that. Incidentally, these happen to be the states which are more red on the map, either map.
Okay, I have a question for Nancy from the audience. I think it might be from an attorney.
oh no.
This is so you made a comment earlier that if you have a huge, delta HHI, there's no point in pursuing a labor market harm. And the question is, when you have a winnable product market harm, that is precisely when you should add a labor market claim, if applicable, to build up the case law, rather than to wait for a weaker overall case.
Absolutely. Could not agree more. I don't want to say that's what happened in Anthem Cigna, but certainly we included a buy-side claim in that challenge. I may be, so there's an advancing the case law motive, and there's a winning your current case, and there's a balance. And so if you think you've got a very strong labor market harm and a strong product market case, maybe that is a great one to bring both of them forward on. If you think you've got a really strong product market case and you're a little worried about the labor market case, maybe you want to wait for a better opportunity is all, just given the vagaries of trying to convince a judge to make that new case law. Judges I have discovered seem not to like that, and attorneys maybe are anticipating that and also kind of averse to getting too far out ahead of the headlights. But yeah, I think that would be a great look for those. I think that would be awesome.
So I think we have time for one last question. So this is kind of the money question. So given limited enforcement resources, should the agencies be shifting resources from mergers with product market overlap to mergers with labor market overlap? And roughly speaking, do you think those will require more or less resources in our normal work?
So I'll weigh in and then let others. I think we need to be strategic. We, the agencies, I can't escape this. I think the agencies need to be strategic in thinking about where to look for this, but I think there's enough concern about what's going on, and we're not sure exactly how important the anti-competitive practices are in the labor, or the anti-competitive effects of merger, say, are in the labor market, that we should be looking for it. We should think about, is this an industry where the two firms merging are hiring from a similar pool of, say, specialized workers? Maybe that's where we start. And add a few questions to the screening to see, is this something we should dig more into? And then if it comes back with, yes, it looks like there's a group that could be harmed by this, we probably ought to think about working that up. As I said, I don't want this to be an open, I don't think you should shift entirely over to this setting, because I'm not convinced that we yet have a reason to think there's a big return to it, and it will be very costly as we're developing the tools, and particularly as you're developing the case law. But I don't think we want to have agencies bury their heads in the sand and not worry about the potential harm upstream.
Could I add, I think one place where DOJ and FTC could have a lot of leverage is in the no poaching and the naked wage fixing, in that one very strong case will send a very strong signal to 6 million employers who, from what I could tell, think there are no penalties, because so far there have been no penalties for no poaching agreements. The penalty has been stop doing this, rather than paying, as far as I know, rather than paying fines. And in the Detroit case, my understanding was the human resource people thought this was kind of the right practice to do. The right practice in the sense they knew it was technically illegal, but they thought that's kind of the normal business practice. And I think a strong case where there are actually penalties as opposed to just cease and desist will send a signal and potentially have a significant effect, much more than enforcement actions, because it'll you don't have the resource. I suspect, given the prevalence of anti-competitive practices, you don't have the enforcement resources to go after all of them. But significant penalties could reduce the practice.
I think that's what the Assistant Attorney General is signaling.
He's signaling, but there's been no announcement yet.
So I will say, from my 2.5 years there, developing a criminal case, you're going to send somebody to jail, takes some time. So
Right.
I at least think now, given they seem to be suggesting that they're working on this, we should take them at face value and say, and think they're looking for a good case to bring. But
I certainly hope you're right, but he suggested it a year ago?
I understand. There are different styles. I think my boss, when I was there, never wanted to promise. He just wanted to deliver. I will say, when that guidance was released, there was a lot of attention by human resource professionals to it. So I suspect it has already had an effect. I think your examples of the franchise no poaches are different, because those probably go through some type of rule of reason analysis, even if there is an enforcement action against them. But just the naked no poach or wage fixing, I think people are on notice.
I was going to make the same point. I think it's important to draw a distinction between no poach agreements between separate firms and separate organizations, and policies within an organization that are vertical restrictions. And the latter has to be judged by a rule of reason. It's hard to find good, positive, pro-competitive reasons for horizontal conduct between ostensibly competing firms. So Section 1 comes into play. And I don't think you should make a distinction between the product market and the labor market.
But Bob, those same contracts say that we're not a joint employer,
Yes, I know.
which strikes me
But
as
it's a joint brand name.
contradictory.
It's a joint brand name, and I disagree with you on whether it's contradictory.
And as far as the knowledge about it, I mean, FTC has brought a case against physical therapists where the text messages are pretty clear. So, I mean, we don't know how much of this goes on, but there is evidence that some of it is going on.
Okay, we are out of time, unfortunately, but this was a great panel, so please join me in thanking them.